If we reflect for a minute, it was in 1992 that the GSE Act was passed by the Democrat side of this institution. And that GSE Act started the affordable housing goals. That was the legislation that basically set up a system, and HUD did the mission enforcement on this, in which Fannie and Freddie went out and bought subprime loans and alt-aid loans in order to meet that requirement. Now, we all know that OFEO was a weak regulator, but I don't think that's the point. I mean, HUD was a strong regulator here, and HUD was enforcing this mission. And in point of fact, when we tried to do something about it, and I specifically carried legislation on the House floor in 2005 to try to allow OFEO to become a stronger regulator, to allow them to do what the Fed wanted them to do, which was to deleverage these portfolios, because at the time they said this is a systemic risk to the entire financial system globally because of what's happening with the GSEs being leveraged over 100 to 1. So this was the desire by the regulators who saw the problem. But HUD did not see that problem, and our colleagues didn't see that problem. The GSE example highlights the inherent conflict of interest that arises when you bifurcate these regulatory responsibilities, as they were bifurcated between HUD on one side and OFEO on the other. And this is why all of our safety and soundness regulators, every one of them, have expressed concern over the idea being put forward in this legislation. The altruistic yet misguided affordable housing goals put Fannie and Freddie at risk, and yes, indeed, as the Fed said, it put the financial system at risk. And by 2005, because of the political interference in this process that pushed those down payments down to 3%, to 0%. You had 30% of the loans that year being people who were flipping homes, never taking possession of those homes, pushing that market up, 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 ballooning that market up, up, up. And yes, the Fed saw that coming. And we weren't able to do anything about it because of the political pressure to prevent an effective regulator from taking the action necessary. And this wasn't realized, I think, by the general public until after the mortgage meltdown. You task a separate agency with this mission, then you've got to expect that altruistic policies, seemingly altruistic policies that they put in place, are going to lead to unintended consequences, because the market isn't deciding these factors anymore. This is being decided by political pull. This is being decided by political interference in the market, which is exactly what happened. Now, Mr. Ireland, we've got the commentary of Sheila Bair, head of the FDIC, against this approach of this separate agency. John Dugan, head of the OCC, against it. James Lockhart, FHFA, he's against this step. Donald Cohn, the Fed's vice chairman, strongly against this step. They've all expressed concern over this idea. Why do you think that is?
Well, I think that, as I said in my testimony, the issues of safety and soundness and the issues of consumer protection are not separate issues. You're trying to deliver good products, and by separating the functions, you tend to frustrate that. Mr. Watt asked for an example. If you go back to the 1970s, fixed-rate mortgages in a rising interest rate environment were a very dangerous product for the safety and soundness of financial institutions. And if you have an agency, a consumer protection agency, that creates a preference for fixed-rate 30-year mortgages, you have a safety and soundness problem if interest rates rise over time and institutions have to fund themselves at higher rates than they're earning on those mortgages.
Now, let me raise another concern I have here, and that's with the legal liability exposure for businesses that would really be on a massive scale. Right now, we have 95% of the lawsuits worldwide filed here. Maybe we can get it up to 95%, 99%. Maybe we could. Mr. Ireland, this here's some of the highlights. It applies a new and high reasonableness standard for the sale of financial products to consumers. It leaves open the potential for an increase in statutory damages for existing private rights of action. It applies a duty of care for financial products. Is it good for the buyer, in other words? It recommends the elimination of mandatory arbitrary provisions in consumer financial products and broker-dealer investment contracts. Do you share any of my concerns with the amount of litigation that's going to come out of this approach?
I think that the people who are most likely to benefit from this law is originally drafted are lawyers.
Madam Chair,
Madam Chair.
Madam Chair, could I quickly respond?